Hi. Now for part two of this chapter, alternative dispute resolution. So in part one, we went through the court system. In this, and you can see there are lots of steps, can take a long time, can be expensive. Alternative dispute resolution is really only for civil matters where people are suing each other or companies are suing each other, things like that. And it takes some of the pressure off the courts. And these are all private actions. So, the definition is the resolution of legal disputes through methods other than litigation, other than the courts, such as negotiation, mediation, arbitration, summary jury trials, mini trials, neutral case evaluations, and private trials. So this all keeps it out of the official courts. Even if you watch something like Judge Judy, that's an alternative dispute resolution. She's not a real judge. This isn't a real state courtroom. Now, there's several reasons why a business might prefer alternative dispute resolution versus litigation. One, it's faster and usually less expensive. Going through the court systems, there's a huge backlog of cases in the court system. So you might be waiting a couple of years before the court can hear your case. And businesses may wish to avoid uncertainty associated with the jury decision. Sometimes juries aren't just looking at the facts, but they're looking at, maybe they're looking at somebody who's suing them who has no money and whose husband has died. And so they're basing their verdict on how they feel about the person, not really the law or the facts. Businesses may wish to avoid setting precedent through court decisions. If you have somebody, let's say you have a former employee, and you work at a big corporation, and that employee is suing for sexual harassment. Well, one, you don't want the publicity, and two, you don't want the precedent set. The precedent would then become, something that later court cases can use. So if you lose in this case, you might lose in every sexual harassment case brought against that person. It's also confidential. So whenever you hear something like the parties reached a settlement before the case went to trial or before the verdict came in, that way they're keeping things confidential. They're not really admitting to wrongdoing. They're not being found to be wrong. So it's all confidential. So they can't be used against them. And, sometimes you still want a business relationship after this lawsuit or dispute. So this can help with that. In some states, they require it for divorce, especially when they're kids, because they want to maintain, they don't want an adversarial process between a husband and wife who will then have to raise children together. So some of the primary ways it's done is negotiation. The lawyers negotiate a deal. Sometimes it's mediation, where you get a third party involved. Same with arbitration. There too, you're getting a third party involved. Some of the advantages of mediation. It helps disputing parties preserve their professional relationship. And you might find a creative solution to the dispute rather than just like, what would it be in law where you have to pay certain damages. You might figure out a way to negotiate new deals. And it offers participants a high level of autonomy. So they can work on this, or they can say there's no more point to mediation. The disadvantages, it appears to be an equal process. Sorry for the interruption. So I was talking about disadvantages of mediation. sometimes some parties enter into mediation with no intention of finding a solution. They're just using it as a delaying tactic. So this could happen. What their goal is then, when they're just using it as a delaying tactic, is to drive up the cost for you, for the other party, and hoping that it'll become too expensive for you to pursue. Arbitration, the next level. And here you would hire somebody who would actually act as sort of a private judge. It's more efficient and less expensive than litigation. Parties have more control over the process of dispute resolution because they choose the arbitrator and determine how formal the process is. So they can sort of set their own rules. So they're not bound by the court's rules. And then you can hire, as in your arbitrator, someone who's extremely knowledgeable in that field. You know, maybe they're a scientist, or that they have been a lawyer in a certain field for a long time, so they really know the law in that area. And the arbitrator has greater flexibility in decision making. Now, judges are like this. All we can do is have you pay damages. Maybe there's something that's built a little bit more creative that the arbitrator can come up with. Disadvantage of arbitration. Yeah, as it becomes more common, the price is going up. That happens. You can't really appeal an arbitration award, so you're kind of stuck with it unless you then take it to the trial courts. And often, as a condition of arbitration, is you say you won't. And there might be a loss of civil rights and remedies available through litigation. And companies and employers might effectively hide their disputes through arbitration. It's just like, it's now public, it's private, so their scandals won't be revealed. Binding arbitration clause. Sometimes in contracts, like an employment contract, there might be a provision mandating that all disputes arising under a contract must be settled by arbitration. Could be your insurance company. You have to be really careful about this. And the clause also typically states how the arbitrator will be selected. If you are in a binding arbitration agreement, the parties must resolve the dispute through arbitration. So this might not be working to your advantage if something comes up, but you've already signed it. Some tips for creating a binding arbitration. Identify what you wish to arbitrate. Make arbitration clauses bilateral. State which party will pay for the arbitrator's fees. And ensure arbitration is cost effective. Specify how arbitrators are selected. Identify arbitration costs. Avoid limitations on remedies. Consider other parties when determining where to hold arbitration. So as I said, this can really box you in if you agree to this too early. So you want to really weigh your options. I mean, if it's for a job, you might be signing it because you really need the job. Or you might be able to take parts of it out, saying for disputes related to this or that. Okay, so that finishes up the second one, and good luck.